Filing for custody when your child lives out of state can feel like an uphill battle. A lot of parents think that they can't take any legal action if their child doesn't live in the state where they currently live. But that is not always the case. In this video, we will clear up those misconceptions and walk you through the steps, from figuring out your child's home state to dealing with jurisdictional issues and to filing for emergency custody orders when time is critical. Navigating custody issues is not always easy, but knowing your rights makes all the difference. Please check out the rest of our channel for more practical tips. What is jurisdiction and how does it impact child custody cases? Jurisdiction determines which court has authority to make a determination regarding your custody case. When parents are in different states, jurisdiction can be complicated and you can't just file anywhere. There is a law called the UCCJEA, which determines where you should file your custody case. And almost all states have adopted this law. The UCCJEA stands for the Uniform Child Custody, Jurisdiction and Enforcement Act. How is the child's home state determined in a custody case? Typically, under the UCCJEA, home state is defined where the child has resided for the prior 6 months. If your child recently moved, their previous state may still qualify as their home state. There are exceptions if the child hasn't lived anywhere for 6 months or there is an emergency. Can you file for custody in a state that isn't the home state of the child? Yes, in some situations. In Pennsylvania, it might be possible if the child has a significant connection to the Commonwealth of Pennsylvania. If your child no longer has a home state, a court can assume jurisdiction if a parent and child have significant ties, like doctors, relatives, or their schooling is within that state. The second option is when the court can assert emergency jurisdiction. This can come into play if the child is in danger, for example, domestic violence or neglect, and courts in Pennsylvania can issue temporary emergency orders, even if it is not the home state of the child. When are emergency custody orders granted? In Pennsylvania, emergency custody orders may be granted when a child is at immediate risk of harm. If you believe the safety of the child is at risk, it's important to consult with an attorney to determine if your circumstances rise to the level of an emergency. It's important to have documentation or some form of evidence to show to a court that an emergency situation is arising. How long do emergency custody orders last? Emergency orders are temporary and designed to protect the child immediately. The length of time of the emergency order is going to depend on what court ultimately has jurisdiction over the case. If another state is the child's home state, that state may still have final say on any long-term custody orders. Can you modify a custody order from another state? Yes, but only if jurisdiction is properly transferred. It's important to work with legal counsel when transferring the jurisdiction of the courts because it can be complicated and an attorney can assist you with this process. Here are some tips for parents dealing with interstate custody issues. Keep detailed records. Communication logs, visitation attempts, missed calls, anything to show what's going on in your particular situation. Follow all court orders to the letter, especially if there's already a custody agreement or custody order in place. Work closely with a family lawyer who understands interstate custody laws. And avoid taking matters into your own hands, like moving a child across state lines without court approval. It could hurt your case.